Hello, Ms. Buanes and everyone who's watching. Today, I would like to bring your attention towards our business law group video presentation, which will be presented by me, Edward Tan, as well as my other group members, which are Oh Tzu Hong, Ho Yen Hong, Do Han Wei, and lastly, Goh Myung Heng. In this video presentation, we will be reviewing a case entitled Fardy v. Skinners 2001, as well as a similar case which we will be comparing later in the presentation, which is related to Fardy v. Skinners. First and foremost, I will be explaining the facts on the Fardy v. Skinner case. Alright, the case begins with the plaintiff, which is Fardy, who has instructed the defendant, which is Skinner, who also happens to be Fardy's surveyor at that time, to prepare a survey on a large estate that he was considering buying at that time. In this request, Fardy has specifically requested Skinner to make sure that the property, which was 15 miles away from an airport, will not be greatly affected by aircraft noises, as Fardy does not want to be disrupted by the aircraft noises every day, as well as he does not want to live on a flight path. After concluding the survey requested by Fardy on the large estate property, Skinner provided Fardy with a 38-page report which includes his opinion that the property was not likely to be significantly affected by the aircraft noises. With that, Fardy was really convinced by the report prepared by Skinner. Thus, he proceeded to make a purchase on the property with a grand total of £420,000 as well as an additional cost of £125,000 on the property's renovation. However, after the purchasing of the property, Faraday realized that the survey report given by Skinner is inaccurate because the property that he bought was substantially affected by aircraft noises every day. Because of that, Faraday decided to seek damages for the breach of contract which was agreed prior to the purchase of the property. Alright, that's all for my presentation. Thank you.
Hi, my name is Uzi Chong and I'm here to present about a legal issue discussed in a Farley v. Skinner 2001. Firstly, with Farley informing Skinner beforehand in order to do a research on an issue of aircraft noises around the property's location. However, Skinner has failed to inform about the presence of the aircraft holding area, which has generated a loud aircraft noises at the nearby Gatwick Airport, which was close to purchased property. With that, Farley claimed that the report provided by Skinner, who was then his surveyor, was inaccurate and has breached the agreed contract made between them. Farley has since chosen to seek compensation for the damage occurred in terms of diminution and discomfort of purchased property caused due to the aircraft noises, where he stated that such loss were still revocable even though there is no sign of financial loss. Lastly, Farley also claimed that in order to establish physical discomfort, it was not mandatory for him to provide a physical injury. That's all from me. Thank you.
Hello everyone, my name is Ho Yen Hong and I'll be presenting about the outcome of the Farley v. Skinner case in 2001. When the first principal claim was made by the plaintiff Mr. Farley on the diminution of property caused by the aircraft noises, the House of Lords found that the purchase price coincided with the open market value of the property after taking the aircraft noises into consideration. Hence, they have decided to dismiss the principal claim. The House of Lords stated that this case was exceptional, in which an important term of the contract was to provide pleasure, while also stating that if the cause of inconvenience or discomfort is a sensory experience that includes sight, touching, hearing, smell, or taste, which in this particular case is caused by the aircraft noises which affects hearing, damages can subject to the remoteness rules and be recovered. With that, after listening to a professional sound expert, the House of Lords decided that the noise in question could be regarded as sufficient physical interference to be treated as inconvenience and discomfort. So the defendant, Mr. Skinner, was liable to pay for the damages for the fact that the purchaser, Mr. Farley, suffered exactly the kind of discomfort and displeasure which he had tried to avoid in the first place before purchasing the property. Finally, the House of Lords made a final judgment for the case in which the plaintiff, Mr. Farley, will recover £10,000 for his discomfort as damages could be recovered for the loss of a pleasurable amenity which may not necessarily be of economic value, but if they are of importance to the claimant, which is Mr. Farley. That's all from me. Thank you.
Hello, my name is Tohan Wei, and I will present about our group's opinion on the outcome of the Farley v. Skinner case 2001. In our opinion, all the judgments made by the House of Lords were precise and lawful. Firstly, the decision to dismiss the principal claim made by the claimant, which is Farley, for the diminution of the value of the property was precise, as the purchase price crashed with the open market value after taking account of the aircraft noises. Moving on, the decision for Skinner to compensate Farley of a total of £10,000 was also lawful, as the contract that was made before the purchase of the property has clearly informed that the surveyor, which is Skinner, should ensure that the property was not disrupted by nearby aircraft noises. However, Skinner has been negligent by not informing the claimant of a nearby aircraft holding area near the property, which will disrupt the enjoyment and peacefulness of the property. Thus, this has resulted in a breach of an agreed contract. To conclude, had the surveyor carried out Farley's instruction properly, the plaintiff, which is Farley, would have been able to avoid the purchase of the property. Hence, it can be summarized that Skinner has breached his assigned duty. Thank you.
Hi, my name is Bom Myung Heng. Today, I will be presenting on behalf of my group Watts and Morrow's 1991. I would like to start off by saying, in a similar case, I'll be reviewing Watts and Morrow's in prior of Farley and Skinner. In this slide, we'll be focusing more onto the legal issues and facts of the case. Moving on to the facts of the case, Watts asked Morrow to conduct a comprehensive survey on a home he wanted to buy. The property was in a good condition according to Morrow's report, and deficiencies could be addressed as a part of routine maintenance and repair. When Watts bought the house, he discovered significant flaws that required a sum of £33,000 to fix. For that reason, Watts had filed a claim for breach of contract. Moving on to legal issues discussed, because Morrow failed to discover the serious flaws, Watts claimed the survey was substandard in breach of contract. Watts attempted to recoup the cost of repairs, as well as additional damages for the emotional suffering caused by living on a construction site for several months. Watts purchased the house based on the report, although it was not in the condition mentioned in the report. As a result, he argued, the adequate measures of damages was the amount required to restore the property to the state stated in the report. The excess purchase price paid in reliance on the report, according to Morrow, is a proper measure of damages. He further claimed that the damages for mental health anguish were non-recoverable. Moving on, moreover, the outcome of the case where Watts was compensated for excess purchase price paid in reliance on the report rather than the cost of the repairs. The amount needed to put Watts in position where he would have been in if the report had been properly prepared was the proper assessment of damages. As a result, the loss he sustained was the difference between the property's worth as indicated in the report and its true value. Damages for bodily discomfort were granted a little amount. So, comparing the Farley and Skinner case with this case, we can now both see that the claimant received compensation due to damages in discomforts. Last but not least, I would like to conclude this presentation, and I would like to thank all of you for giving your time listening to our presentation. Thank you.